Good afternoon. The time is 12:42, and I'd like to call the December 11th special called board meeting to order. As a reminder, this meeting is being broadcast, still being broadcast via the internet. So at any point those attending in person, including the audience, may be visible to anyone watching online. I'd like to please excuse the absence today of Javed Anwar, Cody Campbell, and Welcome Wilson due to duties requiring their attention elsewhere. Do I have a motion to approve these absences?
So moved.
A motion by Mr. Raven, second by Dr. Farias. All in favor?
Aye.
Motion passes. Please record in the minutes that we have a quorum. Let's see, the first item is really introduction of our new board member, Sam Thorne. Sam and his wife Susan own and operate incomparable Camp Ozark, one of the largest residential summer camps in the nation. In addition, Mr. Thorne is the executive director of Camp War Eagle, a non-for-profit year-round youth development organization for underserved children developed in cooperation with the Walton Family Foundation of Bentonville, Arkansas. Additionally, Mr. Thorne is the chairman of the Camp Ozark Foundation and Ozone Ministries, which provides year-round support for youth in 8 cities across the southern United States. He is the founding director of Ozark for All, a summer camp experience for inner-city children, and has served on the board of directors of GAP Ministries, which provides community development services to the indigent population of southwestern New Mexico. Mr. Thorne is also a featured speaker for a national teen absences program. Mr. Thorne received his BBA from Texas A&M in 1970, his MBA from the University of Texas in 1973, and his Doctor of Jurisprudence, summa cum laude, impressive, from the South Texas College of Law in 1977. While at Texas A&M, Mr. Thorne served as head Yell leader and was member of the Corps of Cadets. Sorry.
That's a lot to say.
A little transposition there. Head Yell leader, was a member of the Corps of Cadets and a varsity baseball squadsman. Mr. Thorne served as chairman of the 12th Man Foundation's Board of the Trustees, coordinated the redevelopment of Olson Field at Bluebell Park, co-chaired the university-wide Kyle Field Redevelopment Committee, as well as chaired the $225 million campaign for Kyle Field. Now, that was an effort. Mr. Thorne is an active member of the Athletic Ambassadors and the Houston Champions Council. He formerly served as president of the Southwest Houston A&M Club, area representative for the Association of Former Students, class agent for the class of 1970, and president of the Association of Former Yell Leaders, and is an active member of the Letterman's Association. In 2013, Mr. Thorne was inducted into the Texas A&M Letterman's Association Hall of Honor for his efforts on behalf of Texas A&M athletes. In 2015, Mr. Thorne was inducted into the Corps of Cadets Hall of Honor, and in 2016, Mr. and Mrs. Thorne were awarded the prestigious E. King Gill Award for their efforts on behalf of Texas A&M athletics. Mr. and Mrs. Thorne have 3 children: Scott married to Cecily, Chris married to Cece, and Angela married to Stephen Shaw, as well as 13 grandchildren. Anyway, welcome to the board. Would you like to say a few words?
No.
Well, there are a lot of words in your bio, I tell you what. So maybe, anyway, that's quite an impressive series of accomplishments. So congratulations, and really happy to have you with us. Okay, so our next agenda item is matters relating to the full board. This is 3A, proposed rules. Anyway, so agenda item 3A1 is consideration of adopting the Negotiated Rulemakings Committee. Oh. Well, public testimony. Okay, so we don't have any public testimony, right? And so we'll move on to agenda 3. And by the way, I've appointed early, when the meeting was introduced, Mr. Thorne to the Cap and Cause Committee. So I'll await and when Cody is here next board meeting to make his appointments. That was the one thing that I forgot. Okay. So, agenda item 3A1 is consideration of adopting negotiating rulemaking committee's recommendation to the board relating to the proposed new rules for Chapter 4, Subchapter T, Sections 4340 through 4347, and proposed revisions to Chapter 4, Subchapter D, Section 4.85, and Chapter 9, Subchapter L, Subchapter Lima, Section 9.555 of Board Rules concerning required degree plans for students at public institutions of higher education in Texas. Dr. Stacy Silverman, Interim Assistant Commissioner for Academic and Workforce, will present this item as available for any questions.
Thank you, Chairman Stedman. So a degree plan requirement for students at public institutions of higher education is now required per Senate Bill 25, Senate Bill 1325, and House Bill 3808. The intent of the new subchapter is to establish provisions enacted by the legislation, and it establishes the policies and procedures regarding the required filing of degree plans for students enrolled in public institutions of higher education. A negotiated rulemaking committee met on September 24th and provided the board with recommended rules for implementation of required degree plans for students, including institutional and student responsibilities. The rules really mirror the language in Senate Bill 25 and 1325 and House Bill 3808, and require students to file a degree plan earlier than they have in the past. Students enrolled in an associate's or bachelor's degree program should file a degree program with the institution before the end of the semester or term in which the student earns a cumulative total of 30 or more semester credit hours. Students who enroll in dual credit coursework should complete a degree plan no later than the second regular semester or term in which the student successfully completes 15 or more semester credit hours. The idea is that if students understand their educational path as early as possible, it will deter them from taking courses that don't apply and give them a better understanding of the courses that they will need to take. 2 comments were received and were shared with the negotiated rulemaking committee. The comments are included in the board materials, and the negotiated rulemaking committee agreed with the staff recommendation and recommends adoption of the proposed rules.
Okay, do you have any questions? Yes.
Thank you, Mr. Chairman. So Dr. Silverman, how, I think this is a great idea. It's probably long overdue, but how does this policy increase the need for counselors at the university? If we have all of these students who are now going to be going to counselors and getting degree plans worked out, how is the university going to handle the additional personnel needed to accommodate the new students coming through the door filing degree plans?
So that is an excellent question, and the negotiated rulemaking committee did discuss the fact that it is going to be additional burden on the institutions to do this. The one comment that was, one of the 2 comments that were made was related to the fact that currently students enrolled in dual credit courses are often identified by the institution as non-degree seeking. So the institution doesn't have to file a degree plan for them. So this is a big change, and it's going to require the institutions to do some more administrative work, to do more counseling. But, in an effort, I do think it's going to, certainly the goal is that this approach clearly outlines to a student who's in high school, who's taking dual credit, what they need to take in the order that they need to take it. So.
And my second question is, how does this word get to new students, new college students?
That is going to be something hopefully the institutions will help those students learn about.
Yeah, good question. This is, it kind of relates to that whole question of hours and not being able to transfer, and students graduating with 150 hours or something, and of course often that racks up student debt. So yeah, big question, a big issue that the legislature had addressed this session. Okay, any other questions? May I have a motion to approve the negotiated rulemaking committee's recommendation to the board relating to proposed new rules for Chapter 4, Subchapter T, Sections 4.340 through 4.347, and proposed revisions to Chapter 4, Subchapter D, Section 4.85, and Chapter 9, Subchapter L, Section 9.555 of Board Rules concerning required degree plans for students at public institutions of higher education in Texas.
So moved.
Motion from Mr. Raven, second.
Second.
Second by Dr. Farias. All in favor?
Aye.
Motion passes. Agenda item 3A2 is consideration of adopting negotiated rulemaking committee's recommendation to the board relating to the proposed new rules for Chapter 3, Subchapter B, Section 3.16, and proposed revisions to Chapter 4, Subchapter A, Section 4.2, and Chapter 4, Subchapter A, Section 4.7 of Board Rules concerning required transcript notation when a student is ineligible to re-enroll in an institution of higher education due to non-academic or non-financial reasons. Members, you have a supplemental materials on the goldenrod in this sheet. That's the 3.A2. You can read at your leisure. But anyway, Dr. Silverman, would you like to present this item?
Absolutely, thank you. Negotiated rulemaking took place on October 25th and resulted in the proposed new Section 3.16 of the Administrative Code, new in Chapter 3, Subchapter A. The new section requires transcript notation when a student is ineligible to re-enroll due to non-academic or non-financial reason. The intent of the amendments is to update existing rules to align with new and current statute and rule references regarding notations on transcripts. The amended rules will affect students ineligible to re-enroll in a public and private or independent institution of higher education in Texas. Additional revisions were also needed to amend existing rules to include reference to the new transcript notation requirements. Chapter 4, Subchapter A, Section 4.2 would be amended to reference authority provided in Education Code 519364. Chapter 4, Subchapter A, Section 4.7 would be amended to reference Chapter 3, Subchapter A, Section 3.16 requirements. These revisions provide instruction to institutions of higher education and private and/or independent institutions of higher education regarding transcript notation for students ineligible to re-enroll for a reason other than academic or financial. The revision also adds guidelines for transcript notation removal. One comment was received and shared with the negotiated rulemaking committee. Staff recommended no change to the proposed rules. The negotiated rulemaking committee convened for a second meeting on December 6th and reached consensus on the proposed rules. The negotiated rulemakings committee recommendation is for adoption.
So,
Yes.
why would a student be ineligible to enroll due to non-academic or non-financial reasons?
If they did something that was
Bad.
bad.
Some mental
Very
health
bad.
issues.
So,
I mean, like criminal or Ms. Williams suggested mental health issues, that kind of thing?
Criminal.
Sexual assault would be,
but my question is, how does this legislation define non-academic and non-financial?
I don't have that right in front of me, but I can certainly get it for you
but
in terms of the actual bill.
Because isn't that the question? I mean,
Right,
when you
this
say
is-
non-financial, I mean, that could mean anything, right?
So in the discussion in the committee, the issue is really that a student who could, okay, great, thank you. A student who was basically kicked out of an institution could then go re-enroll in another institution because there would be no other way for the institution currently to know that that student had done something so bad that they had to be relieved from the institution, let go.
Right.
So, and let me see exactly what. It's if they're under a disciplinary process. So if they're under some sort of disciplinary process and it's not academic or financial, that they can't re-enroll because of a disciplinary issue, then it's got to be noted on their transcript.
And that's the way the term non-academic and non-financial is described, is defined in the legislation?
It is not really defined.
Yeah, somebody had something in mind, and I guess, Commissioner has mentioned sexual assault as being an obvious one.
Surely, right.
Where you'd want to broadcast that information and let other institutions know. But anyway, it sounds like it seems like it would be hard to get kicked out of a college, wouldn't it? No?
I
I mean, for non-academic reasons?
Yeah.
Well,
But if you sexually assault
my
somebody.
concern is that if it said, due to the commission of a felony, I get it. Okay, I get that. That is what it is, or commission, or committed, or misdemeanor, what have you. But when you say non-academic or non-financial, what does that mean?
It means any reason you've been kicked out. So,
Other than non-academic or non-financial?
correct.
But it's also subjective.
Yeah.
So
Yeah.
That sounds like.
what might be bad to one institution might not be bad to another institution.
Like freedom of speech issues. I don't know. We're getting kind of off track because the legislature
with
had
you.
something in mind.
The discussion, there was some other legislation that came up when, that I was testifying on that. And the discussion that came up was specifically focused on when there are violent offenses or a student might be a risk to safety. So that was the primary focus, but the legislation itself is framed more generally.
Okay.
Okay, well, may I have a motion to approve the negotiated rulemaking committee's recommendation to the board relating to proposed new rules for Chapter 3, Subchapter B?
Can I ask a question
Oh,
first?
sure.
Is there any sort of, where this rolls off your record, or does this follow you forever?
Yes, absolutely. So the committee did discuss that. So if someone were convicted or not convicted of whatever it was that they were being accused of, then there is a way for them to remove that from that transcript notation. Absolutely.
The institution makes that determination.
Correct.
No.
Yeah, there sounds like some due process issues that are like big time here, but that I don't think that's the province of us to opine upon. But it's important, and hopefully the committee can soften whatever gaps in the legislative due process or whatever that the committee finds exist. So, any other questions?
One last question. Can the rule define, can that be part of the process? The rule can define what?
So yes, to that point, and these are all excellent questions. Within your packet, you've got the proposed rules. It does say institutions have the policy must include the definition of prohibited behavior, sanction for violations, protocol for reporting and responding to reports of sexual harassment, sexual assault, dating, violence, stalking, that complies with the electronic reporting requirement, and interim measures to protect victims of sexual harassment, sexual assault, dating, violence. Oh, wait, sorry. I'm on, that's three, that's one you're going to hear about next. But
Well, anyway, back to Ms. Williams' question. I mean, can the rule? I guess it's whatever the university or the institution thinks is a merits expulsion, and that's pretty open-ended. Is that right, Commissioner?
That's correct. So there could be an expulsion because someone had committed a serious act of vandalism or something like that, and that could be a non-academic reason. They'd be under a disciplinary. They might have to sit out a semester or something like that, but that would be noted on the transcript. But again, this specifically came up because of some high-profile cases where students were not permitted to re-enroll in an institution because there was a disciplinary proceeding related to a sexual assault. The student went and then the student went and enrolled at another institution. And sometimes there's even been cases where then other incidents have occurred at other institutions, but the institution that the student enrolled at wasn't aware that the student wasn't eligible to re-enroll.
Gotcha.
But I get that, and I see where that's perfectly reasonable and appropriate. But this doesn't say that. I mean, that's my concern. It doesn't say, it doesn't give you the impression that this rule is designed to address that sort of behavior. I mean, this could be interpreted if I have too many parking tickets.
Or even worse, in my view, a free speech, issue that offends somebody.
Right.
And then the institution would say, well, you're just a troublemaker, you're out of here.
Right, exactly.
But anyway, obviously, there's some interest in the committee. If you could keep us informed, or the board, but by the board, if you could keep us informed about, what the committee's doing and how these rules kind of develop.
Absolutely.
Okay, so may I have a motion to approve the Negotiating Rulemaking Committee's recommendation to the board relating to proposed new rules for Chapter 3, Subchapter B, Section 3.16, and proposed revisions to Chapter 4, Subchapter A, Section 4.2, and Chapter 4, Subchapter A, Section 4.7 of Board Rules concerning required transcript notation when a student is ineligible to re-enroll in an institution of higher education due to academic or non-academic or non-financial reasons.
So we need to move on to.
No, I'm looking for a motion.
I'm sorry. I'm just.
Would you like to make the motion? No, you're not on the board. Okay, so what board member?
It's been a day. I'll move.
Okay, Ms. Swartz, motion. I have a second.
I'll second.
Ms. Williams, second. All in favor? Aye. Motion.
Mr. Chairman, note my abstention.
So Mr. Raven has abstained from this vote. Okay. Would you note that, Mr. Franz? Okay. Next item is Agenda Item 3A3, consideration of adopting the Negotiated Rulemaking Committee's recommendation to the board relating to proposed repeal and replacement of Chapter 3, Subchapter A, Sections 3.11 to 3.15, and proposed new rules for Subchapter 3, Subchapter A, Chapter 3, Subchapter A, Sections 3.1, 3.10, and 3.16 to 3.20 of Board Rules concerning required reporting rules and policies regarding certain incidents of sexual harassment, sexual assault, dating violence, and stalking at post-secondary educational institutions. You have, members, you have supplemental materials for this agenda item printed on goldenrod paper. Dr. Silverman, if you want to
Thank you.
present this item.
Yes. The intent of the new subchapter is to establish provisions enacted by House Bill 1735 and Senate Bill 212, passed by the 86th Texas Legislature. The proposed new subchapter A establishes the requirements for policies and procedures regarding sexual misconduct at post-secondary educational institutions. A negotiated rulemaking committee and an advisory committee provided the board with recommended rules, and the legislation requires that the board have rules in place by January 1, 2020. The committee recommended rules that delineate how institutions of higher education should handle reports of sexual harassment, sexual assault, dating violence, and stalking at institutions of higher education, while also staying compliant with applicable federal law. The rules include provisions to require public, private, and independent institutions of higher education to report incidents of sexual harassment, sexual assault, dating violence, and stalking, adopt a policy on such incidents, implement electronic reporting protocols for such incidents, which includes the option of anonymous reporting, develop a comprehensive prevention and outreach program, establish penalties for noncompliance, and provide amnesty or immunities to students and employees who report incidents of sexual harassment, sexual assault, dating violence, and stalking. The proposed rules were posted in the Texas Register in 2 segments on November 1st and 8th. The public comment period ended on December 1 and 8. 6 comments were received, 1 from Doctors Hospital and 5 from the University of Texas at Austin. The committee met via conference call yesterday and agreed to the proposed rules with 1 alteration. The committee agreed with staff to add the word final to section 3.11B to clarify that the obligation to provide information to another institution regarding a student who violated the institution's sexual misconduct policy is in relation to a final determination, which ensures that the integrity of the disciplinary process is protected. The full detail of comments are included in your supplementary materials. The negotiated rulemaking committee's recommendation is adoption. And I have with me here Dr. Mary Smith, who served as the facilitator of the negotiated rulemaking process.
Yeah, Mr. Raven.
Thank you, Mr. Chairman. My question is this: as I understand it, that the university has a responsibility to report the information if a university employee reasonably believes that something happened, correct?
Correct.
So if, let's just say a university employee doesn't believe anything happened, but the police believe that something did happen. In that circumstance, the university has no obligation to report that to the police, correct?
Right. They use the reasonable person theory, essentially. If an individual reasonably believes that this occurred, then they are supposed to report it to their Title IX coordinator.
I guess my concern is that what about the circumstance where law enforcement believes something happened, that a crime was committed? University employee does not believe that a crime was committed. What happens then? Because the reasonable person is not talking about law enforcement, it's talking about a university employee.
There was one provision in the legislation that requires that the university do report at least to one outside law enforcement agency. There's a lot of talk at the committee meeting about whether or not the inside police department within the university system would be adequate for that, and that was agreed upon by the committee members that that was not adequate. They had to report it to the local law enforcement outside the university system.
Could I ask a clarifying question? If I understand your question, so suppose that law enforcement believed that an assault had taken place, the university official did not believe an assault had taken place, then would the university still be under? Would they still be under an obligation to report under Title IX?
That's my confusion. It doesn't. The way it reads. The way this reads, the answer is no, the university would not have an obligation. So if I'm reading this correctly.
I think it depends on your interpretation of Section 3.5 in the proposed rules about the employee of the post-secondary institution who'd receive information regarding the occurrence of incidents. So if the information were received by law enforcement, then they've received information about it. Now that they could, so you're saying you think there may be too much discretion for the university to say, but we're going to dismiss that report?
I mean, my question is born out of confusion, but yeah, I mean, that's when you say employee, I assume you mean university, and it says that has the reason to believe the information is reliable. I mean, that doesn't make, I mean, it just doesn't make a lot of sense to me in terms of, I mean, someone could tell me something that I'd say, I don't believe that. And this person, this alleged victim, could go to the police, and the police says, okay, we will do an investigation because we think probable cause exists. The university didn't do anything because The person came to me, I said, I don't think it's reliable. Police says, I think there's probable cause. University has no obligation to call the police. If I'm reading this the way I'm reading it, if that's correct, and I'm not suggesting that it is, I'm just raising the question. But I mean, but that's what it says.
So a key question is, does the institution have that flexibility under Title IX, where the university could discount or dismiss what law enforcement believes is probable cause?
Right.
So,
Check that.
I don't know.
Yeah, I actually would be concerned with the other situation where the university believes that the sexual assault existed and the police don't. So I don't know. This is a really complicated area, and I'm not sure why the coordinating board has the expertise to delve into these kind of legal issues. But obviously the legislature is concerned about it, and we're just charged with what? We're just approving the rules.
It's a dramatic expansion of the coordinating board's authority pertaining to these issues. The legislature wanted the coordinating board to be able to weigh in because the universities, public or private institutions, under the Section 3.19, if the coordinating board determines that a post-secondary institution, public or private, is not in compliance, the coordinating board could assess an administrative penalty up to $2 million. So it's an expansion of the board's authority.
And so Commissioner, what is our sort of new police function, or how is that like? It sounds like an audit, like Mark Pale audit or something. What are we going to do to satisfy the statute?
So I think that's likely that we're going to have to. Already, we're working with through Mark's division works with institutions on, and so. This is, we think, one of the areas that we would have to add some capacity to be able to reasonably implement this new legislation.
And I presume, that you will have reports to the board. Yeah, because there's a concern all the way around, and I think it's a legitimate concern about, well, not only what is happening out there in the field at the institutions, but also what our specific role is in assuring this compliance. So, and I guess we need to figure out what province, or probably AOC, don't you think?
Yes.
Yeah, we're probably under the AOC, audit function, a review. So, Dr. Smith?
Actually, as you just approved the Training Advisory Committee, the Title IX Training Advisory Committee, they were a supplemental group of the Negotiated Rulemaking Committee, and they've designed training for a group of individuals on the campus as specified in the legislation. Title IX coordinators and deputy Title IX coordinators, reasonable employees and mandatory reporters, and confidential employees and student advocates. So if you were to look at our website now, because the training requirement for these individuals was required actually by December the 1st. So that's now on our website under resources, and so an individual institution is able to download it's 100 slide deck, and each of those types of employees would be trained by specific slides within that slide deck based on the Title IX coordinator's work at that institution. And then in the process of all this, just yesterday, frankly, the Training Advisory Committee finalized the Title IX coordinator report template and the Chief Executive Officer report template, which will also be on that website under the Title IX training information, and they are in the process of developing a PowerPoint presentation for the individuals who are actually using these templates. So that one of the big concerns of the committee was whether or not there was going to be consistency across institutions with respect to the reporting, so that one institution wouldn't look really poor and another institution would look really good because of the way that they were reporting. And I think one of the legislative intents was to ensure that individual institutions were accurately reporting. as a part of this negotiated rulemaking process as a facilitator, and then I was the liaison for the Training Advisory Committee, a lot of the concern was how institutions currently do report. So as one major example, an individual that potentially did commit sexual assault and then was disciplined for that, but ended up going into into a hospital for stress relief for him or herself as a result of this, were recorded as being an issue with respect to a mental health issue rather than a sexual assault issue. So the idea really is to make sure that there's consistency across the report, and I have these templates for you to look at if you would like to do that. That might help you understand how they're perceiving what their obligations are. And as Dr. Silverman just specified, we do have, it's a significant penalty for institutions if they misreport information.
Dr. Frias?
Yeah, I'd like to find out, did the committee, can you give us some background on that? You mentioned the hospital, because there's been a lot of discussion about universities. I'm assuming the hospitals because they have residents or training. So can you give a little background on the hospital's concern?
Actually, they were concerned about it also, but essentially that's, the big concern was whether or not an individual was an employee or a student. So this is just for employees. So there is some talk about potentially the legislation being updated to actually include student reports also. So it's quite controversial, but one of the issues was with respect to the Title IX coordinators with the health-related institutions, and residents and all of that. But basically it's these types of employees and what they're required to report, and then there was a big discussion about whether or not, as Mr. Raven was talking about the reliability of the report. It's really not the responsibility of the reporter whether or not the information is reliable. They're supposed to report to the Title IX coordinator, and the Title IX coordinator is supposed to determine whether or not it's a valid report. And then, of course, there's a whole process of investigation and due process. But nevertheless, the idea is to make sure that the reporting is accurate. This is about reporting.
And so that's our kind of narrow function? In other words, we're just making sure that they report, these institutions report to the coordinating board.
Correct.
Right?
Well, there's as Dr. Silverman was
Well, the Title IX coordinator who then has to report to the court. Well, no, we audit. What?
It's essentially what happened was these two bills,
Title IX
House Bill 1735 and Senate Bill 212, required a negotiated, it is obviously quite controversial legislation. So the legislation required that the coordinating board actually engage a negotiated rulemaking committee, and was all specified. And then, of course, the process is quite complex. There were 24 individual members. Frankly, probably two-thirds of them were actually attorneys on the negotiated rulemaking committee, and they were incredibly careful about how the wording was specified in the rules that we developed for your consideration for the reporting requirements, and who was going to be reporting and what was going to be reported. So I'm glad to pass these out if you like. It does provide you with very specific information about things that need to be reported.
I guess so. I mean, I'm not sure we need to do it before we take the vote, because what we're doing is actually approving the rules that govern our supervision
Correct.
of this process.
And to make sure that that each individual, but they do have policies. I mean, they have to report the Clery Act and I learned a lot from the process also.
Commissioner, we can table this till we can get some.
Well, no, we can't table it. We have a deadline that's statutory, right? They have this thing by January.
January 1.
Yeah, so
The
that's why
training
it's
had
on the
to be-
special called board meeting. So, I mean, obviously, we don't,
But
the
you can
board
always-
doesn't understand it.
So you can always amend the rules later if you need to, but I recommend that we get, so the board get an additional report related to the technical questions on Title IX reporting, legislative intent, some of this other background information, so the board can determine if they need to revisit, amend the rules.
Okay, so that's, with that comment, okay, I would like to read this, and ask for a motion to approve this rule with the understanding that we can amend it and that we will be educated on this complex topic of both legislative intent, I guess statutory, there's federal issues involved, there's state law enforcement. I mean, it's a very complicated kind of subject that somehow you will educate us and allow us to amend the rules if we see fit. Is that sort of that, with that understanding? So,
To be clear,
yeah.
what we're doing is exercising our required authority to establish consistency across universities in what must be reported. Is that correct?
That's correct. The rules and the recommended rules were established through negotiated rulemaking with the institutions. So the institutions have been working together with the agency so that there'd be consistency on that.
So we have a deadline for that, but if perhaps there are questions concerning some gaps or confusion that these may create, we can come back and take care of those.
Exactly, and so basically, I'm charging somebody, probably Commissioner, with just keeping us up to date on this and see how this develops, and just try to educate us, because this is a really
Complex, like you said.
complex and difficult topic that multi layers, and we don't really understand it.
We could provide a report, and we'll also need to provide the board with an implementation plan for how the agency would support the implementation.
Or audit.
Yeah, I think that's where it would probably fall.
Yeah.
So to be clear also, Mr. Chairman, I want to make sure we keep emphasizing, universities and systems, but we did get a concern from a hospital. So I want to make sure, was that hospital part of a system, a university system? Because I want to make sure that everybody's included, especially those that have raised concern.
It was the Doctors Hospital Renaissance.
Yes, yeah, I know them.
Okay.
I know who they are. So, and I want to make sure that, they're not a university, right?
Right.
But they work with the university. So I just want to make sure that we include, Commissioner, especially the people that have made some suggestions or some concerns, and not just think about the universities. Does that make sense?
Mr. Chairman, I'd also like to raise about looking into further how this affects student employees and how that can affect, in their different capacities, whether this applies to them or not.
You would think that they would be required to report, and that whole thing, I mean, this really needs to be broken down into really kind of simple, different scenarios and situations, because it's Ms. McKenzie just mentioned, they're only dealing with employees. You think it'd deal with student employees and what kind of evidence and all that. It's a very complex topic. So anyway, just kind of note that we have the ability as a board to go back in and amend it, but then you guys will keep us informed and kind of educate us on what's happening here.
If I could say one thing, and we'll bring it up, we may very well invite members of the committee that were highly engaged in both. Essentially, the Training Advisory Committee was a supplement of the Negotiated Rulemaking Committee, the same members with one exception. We had the legislation required that we have on the Training Advisory Committee a representative from an advocacy organization, and so we did have an individual from TASA, the Texas Association Against Sexual Assault, on the committee, and I would encourage, and we'll bring it up potentially if you'd like us to do that, to show you the training materials, because I can tell you that committee, that met, the Negotiated Rulemaking Committee met initially on September the 23rd. It was such a complex set of legislation, they really could not make a final decision on it. We ended up having 2 more meetings, so essentially 20 hours of negotiation about the rules that you see in front of you here, plus the Training Advisory Committee coming up with the actual training materials to ensure that lots of controversial issues, like, for example, if an individual victim doesn't want to have it reported and they report to the Title IX, how the Title IX coordinator deals with a person that wants to remain anonymous and doesn't really want, it was very complicated. So I can show you on the website, but...
Well, hold on. Okay, so basically what I'm thinking is you do a story, like, you had this situation before this legislation, and then you had these concerns And then what are were those concerns? What was the situation board? What are the concerns? Then the legislation addressed those concerns in this way, and then this negotiated rulemaking body had this input and spent the 20 hours, which I hope we don't have to spend understanding this, and then they had these rules that we are going to approve, or we really need to approve, with the understanding that we can amend them, and we're going to learn about this, we can amend them in the future.
Right.
Okay.
Quick
Any other
comment.
questions?
Just quick comment. So it was, this was approved by our Office of General Counsel. So I'd want Mr. Franz, how do you feel about this with the discussion, what we'd like to propose? I'd like to hear from our General Counsel.
That's a good point.
I thought Mr. Raven's question was the seminal question. I think that, and the answer I think is, you're right, that if the police and the individual who reasonably believes nothing happened disagree, the police can conduct their own investigation, but the university may well not ever have that as a report unless it makes its way, it will make its way ultimately into the Clery Act reporting, because it would be a criminal investigation that presumably resulted in a finding. And to muddy this up some more, my understanding is...
Please.
I think Secretary DeVos will shortly issue new guidance on various standards relating to Title IX and how various individuals in the process are to be treated. But I don't want to get ahead of myself because the guidance has only been issued in preliminary form and it's still subject to change. But I think Dr. Smith's suggestion that the training be made available, I don't want to say be presented at a board meeting because I'm concerned that it might take, I haven't seen the training slides, but I'm told they're very good, and not just by Dr. Smith, but by members of the committee who I personally know. I was not involved with the committee's work, but they're very proud of these training slides and expect that they will pretty well cover the waterfront. My hope would be that those training slides would answer any questions the members would have. I think that if we made those available to each member individually for them to review at their leisure, that might narrow any questions that might result.
Definitely, yeah. Any information? So, okay, so any other questions?
I mean, I guess, again, it's the language. When you say reliable, I mean, reliable has nothing to do with the truth and veracity of what I've been told. Reliability has to do with my perception of you as the outcry witness, as a declarant, okay? I mean, if I think that Bill Franz is not reliable, that has nothing to do with what he just told me. I just don't think he's reliable. And to me, it puts us in an area that I think is very tricky. And so, I mean, that's my concern.
And I guess to follow up on that, I understand that concern. I just don't really understand how we fit into that concern.
Correct.
And so anyway, the whole overview, would be really helpful. And so if we can do that sooner than later, I think that would be important to the board.
Excuse me. Do you want it at the board meeting, or do you want them sent to you?
Oh, no. Send the training slides. I mean, any kind of background stuff that we can get independently, but then you need a presentation, I think. It goes to the history. What was the problem they were trying to address? What did they do to address it? And then what did the rulemaking committee do to implement it? And then what is our role in this process? Those steps. But any background we get before that would be helpful.
Commissioner Keller described one instance concerning notations on transcripts where an individual was able to leave one institution, move to another, and allegedly, at least, commit another egregious offense.
That one I understand.
Okay.
I mean, that was the previous rule.
Then the other was a prevalence of sexual assault, stalking, sexual harassment, general abuse, often primarily of women, on campuses really across the nation, but of course the authors of these bills were primarily concerned with Texas. And that's what this particular piece of legislation and rulemaking was designed to address.
But specifically, I mean, I know that's a significant, big problem, but specifically, somebody must have thought, well, there was underreporting or non-reporting. And so
Yes.
then they passed this legislation to beef up the reporting and then gave it to us to enforce. That kind of sums it up, I guess. So anyway, but more detail would be helpful, and that training, I think, the training slides would be helpful just to see, kind of on the ground, what do these employees face, kind of decisions and situations.
They do have hypotheticals in, so that basically there's an explanation slide, and then the Training Advisory Committee tried to decide whether or not that slide was enough, because obviously 100 slides is a lot, and 30 of them are for the reporting people, so these reports here. But nevertheless, even 60 slides or 70 slides is a lot of slides, but nevertheless, each one, like they would determine whether or not the slide was an explanation enough, or if they needed a hypothetical to help the individual understand. So there's a lot of hypothetical slides also that show what happened and what the individual should do based on what type of an employee they are.
Yeah, and that should be helpful. Okay. So, if there are no further questions, I'd like to ask for a motion to approve the Negotiated Rulemaking Committee's recommendation to the board relating to the proposed repeal and replacement of Chapter 3, Subchapter A, Sections 3.11 to 3.15, and proposed new rules for Chapter 3, Subchapter A, Sections 3.1 to 3.10, and 3.16 to 3.20 of board rules concerning required reporting rules and policies regarding certain incidents of sexual harassment, sexual assault, dating violence, and stalking at post-secondary educational institutions. Do I have a motion? And the understanding that we're going to get educated on this, right? So is that, so, okay, motion by Mr. Raven. The second?
Second.
Second by Ms. Schwartz. All in favor? Say aye.
Aye.
Any opposition? Motion passes. Thank you. Let's see. Agenda item 3B is consideration of adopting the staff's recommendation of the board relating to the acquisition of contract services for Phase 2 of the Identity and Access Management Modernization Program. Ms. Jinjin Sun, Assistant Commissioner of Information Solutions and Services and Chief Information Officer, will present this item as available for any questions. Jinjin?
Thank you, Mr. Chairman, board members. This agenda item is to seek the board's approval for the agency to acquire contract services for the Phase 2 implementation of the Identity and Access Management Project. Identity and Access Management, IAM, is a framework of policies and technologies for ensuring that both our internal and external users have the appropriate access to technology resources hosted by the agency. IAM controls and manages user access and permissions based on the need-to-know principle, which means the user's permissions and access are determined based on the user's job duties and role. The 86th Texas legislature appropriated $215,000 to the agency for this biennium to continue the IAM project, which is also one of the key cybersecurity initiatives we planned for fiscal year 2020. This project will serve to improve the maturity level of the agency's cybersecurity framework by protecting confidential data pertaining to the higher education. At the same time, the new solution will improve user experience and help deliver our resources and services to the stakeholders in a more efficient manner. For Phase 2, we are seeking vendor services to build the agency's new cloud-based solution and help define the multi-factor authentication strategy moving forward. The estimated cost of the Phase 2 implementation is around $200,000. The procurement process for this type of contracts usually takes a couple of months. So I'm seeking the board's approval today to kick off the procurement process in order to accommodate the proposed project timeline and to allow the staff members enough time to work on the deliverables once a vendor is selected. So this concludes my briefing, and I'm happy to answer any questions that you may have.
Think 200,000's enough?
I think so.
Pretty important stuff. Any other questions? May I have a motion to approve the staff's recommendation of the board relating to the acquisition of contract services for Phase 2 of the Identity and Access Management Modernization Project?
So moved.
Motion by Dr. Farias. Second by Mr. Raven. All in favor?
Aye.
Hearing no opposition, motion passes.
Thank you.
Thank you. Agenda item 3C is consideration of adopting the committee's recommendation to the board relating to the request from Texas Tech University for a Doctor of Veterinary Medicine degree with a major in veterinary medicine. Dr. Stacy Silverman, Interim Assistant Commissioner for Academic Quality and Workforce, will present this item as available to answer questions.
All right. I keep forgetting to turn that on. As you all heard about this earlier today, the committee's recommendation is for approval. We do have representatives, but you've heard from them already.
And my understanding that you were going to have to present as a part of this process, so that's it?
That's it.
Okay.
Unless you'd like me to go back and go over the remarks again.
And the Commissioner, do you have a comment?
Just as a West Texan, and I know this is a process that the board, the legislature, the coordinating board staff have certainly worked on closely over the last couple of years. So we offer a strong recommendation for the committee's recommendation.
Okay. Let's see. Do I have a motion?
So moved.
So moved.
Motion by, well, I'll give it to Ms. Williams. Second, by Dr. Farias. All in favor, say aye.
Aye.
Any opposition? Hearing none, motion passes. Congratulations. The final item on the agenda today is agenda item 3D, consideration of adopting the Certification Advisory Council and Commissioner's recommendation to the board relating to a request from Burrell College of Osteopathic Medicine for an initial certificate of authority. Dr. Stacy Silverman, Interim Assistant Commissioner for Academic Quality and Workforce, will present this item as available to answer any questions.
Thank you. Burrell College of Osteopathic Medicine, located in Las Cruces, New Mexico, requests an initial certificate of authority to establish and coordinate clinical clerkship rotations in Texas for a specified number of third and fourth year medical students in El Paso. Burrell applied for an initial certificate of authority as the institution works toward accreditation by the Higher Learning Commission, an accrediting agency recognized by the coordinating board. Burrell is also pre-accredited by the American Osteopathic Association's Commission on Osteopathic Colleges. Burrell anticipates pre-accreditation status will remain until it graduates its first class in spring 2020, at which time it will become eligible for full programmatic accreditation. The initial certificate of authority would be valid from December 2019 to December 2021. The request was initially scheduled for consideration at the July Cause Committee, but was postponed to the July board as concerns were raised by Texas Tech University Health Sciences Center, El Paso. The concerns were related to the availability of clerkships in the area. The coordinating board staff made an attempt to craft a compromise between the two, but no agreement was reached, and the item was removed from the July board meeting. Discussion continued, and as a result, a memorandum of understanding was reached between Burrell and Texas Tech University Health Sciences Center Paul Foster School of Medicine. Subsequent to the MOU between Burrell and Paul Foster School of Medicine, a letter of objection was received by the coordinating board. At its September cause meeting, the item was postponed by the board until the letter could be adequately reviewed. The item was then placed on the October board agenda, but there continued to be objections to Burrell being granted a certificate of authority. As a result, the item was withdrawn from the agency shortly before the October board meeting. Additional concerns were raised about setting a precedence and ensuring that Burrell would limit its operations to the El Paso area under the conditions of the MOU. In December, the coordinating board staff drafted an MOU with Burrell that outlined 7 terms and conditions. Coordinating board staff sought agreement from the Texas medical schools that the MOU would provide additional assurance that Burrell would not infringe on clinical clerkships of other Texas medical schools. The MOU is included in the board materials. Burrell agrees to maintain its accreditation, not pay for clinical rotations now or in the future, that entering this agreement does not impact the existing MOU with Burrell and Texas Tech University Health Sciences Center, El Paso. Burrell agrees to limit the number of 3rd and 4th year medical students in Texas to no more than 30 in each year. Burrell agrees to make clinical assignments in Texas only in El Paso County, meaning it won't pursue additional locations in Texas. Burrell agrees to referring to itself as Burrell College of Osteopathic Medicine, and at no time will it refer to itself as BCOM. And finally, Burrell agrees that effective July 2nd, 2021, 90% of its students designated for training in Texas must be Texas students. Pending board approval, the MOU will serve as a permanent agreement and is attached on the following pages of your board materials. With the MOU now in place, upon approval of this, the Certification Advisory Council and the Commissioner recommend approval to issue a certificate of authority. We do have representatives here from the institution if anyone has additional questions, and I'm happy to address questions as well.
I guess I have a question for the commissioner. I mean, I've watched this process. You know, this has been a seemingly controversial process that in my sort of simple way of looking at it, didn't need to be so controversial because there was an agreement, at least at one of those stages, between the institution most affected, you know, Texas Tech Health Science Center, and Burrell for those particular clerkships, and they weren't needed at the time. And yet there was a lot of concern by institutions, other medical institutions in the state, that somehow this would set a precedent. I'm reminded, and I know that I've talked to Dr. Keller and Dr. Frias about this. It reminds me of George Kennan in 1947. They wrote the article by pen under the pseudonym Mr. X about containment. That is, if we don't stop the commies in Vietnam, we'll lose Oahu next. And so that kind of concern, I think, to some extent is real, to some extent maybe is not, but I think it begs for a legislative solution to figure out what the state wants to do with its clerkships, which are very valuable. So, Commissioner, could you comment on all of that?
Certainly. So, Mr. Chairman, first I would agree. So of course I came late into these conversations, but as the discussions went on, so of course there was an agreement was able to be worked out between Burrell and Texas Tech. There's some issues that came up that are particular to that relationship, particular to El Paso, that were able to be addressed. But you're correct that as these discussions progressed, other medical schools, other health science centers across the state were concerned about what the particular implications might be for their institutions or the precedent that it would set. And so around the relationship with Burrell and implications for other communities, other institutions, so I was pleased and grateful to all of our public medical schools and health science centers for participating with us and with the coordinating board and being able to work out a strong agreement that will stand in parallel to complement the particular agreement with Texas Tech. And I think that itself is an important precedent, both in that collaboration and in the nature of the agreement, especially as it pertains to serving Texas students and Texas communities, that is going to be important going forward. It's also surfaced some important issues, considerations that the board should take up, both with regard to our own rules around certificates of authority and certificates of authorization, where there's some confusion, and also these broader issues with the legislature, that it'll be important in this next session for the legislature to weigh in. It's absolutely the case that there's a shortage of high-quality clinical slots available, and there are a number of national medical schools, some of which are among the very best in the world, that are looking to Texas as a place to place students, and the legislature does need to consider how they're what the expectation should be and what the limitations should be that pertain to all institutions, both our in-state and our out-of-state both our in-state and our out-of-state institutions.
So anyway, I don't know how we can suggest or work with the legislature that this is a problem. I mean, obviously the medical schools are very concerned, and they've been concerned through this process, but I think, you know, the state needs to come up with an overall policy about how much we're going to allow foreign, non-Texas medical schools, whether foreign or domestic, to get those clerkships, and say issues like, you know, well, would we allow them to pay for them, which, you know, there's bidding war issues. So anyway, these are real legitimate concerns, but I guess my sense, I mean, for what it's worth, is that this memorandum of understanding, both with the coordinating board and with Texas Tech, is pretty solid and solves that problem for this case. Mr. Raven?
Thank you, Mr. Chairman. I guess my concern is there's an MOU in place for New Mexico with Texas Tech, but what if Oklahoma wants to do it? What if Louisiana wants to do it? I mean, where does this stop? Well, because it seems like to me that if we allow this, you're going to have an onslaught of states invading Texas, taking our medical students.
So this is already an issue. So we have students from Cornell in Houston. We have a number of medical schools across the country who have students in clinical rotations in Texas. So both in terms of our rules for where there are certificates of authorization or certificates of authority granted, this is something the coordinating board should consider. But to echo the chairman's concerns, I think this is something that the legislature would need to weigh in on for this next session. So it'll be something that we'll need to deliberate about.
Mr. Torn?
Yeah, I'd like to know from Ms. Schwartz if this makes sense for El Paso.
Thank you. It makes a lot of sense for El Paso. Earlier, we were talking about the importance of experiential learning in one's own community, educating students from their community, in their community, and letting them practice there, get internships so that they get acquainted with the employers and want to practice. We've been a medically underserved community for forever, and these two medical schools, the Paul Foster School of Medicine and the Burrell College of Osteopathic Medicine, are two efforts that our communities worked hard on to bring medical education to our region. If the students who we're educating, who a lot of them are actually El Pasoans going to southern New Mexico to get their medical education, which is a very common practice in far west Texas, where we're very geographically isolated from everybody else. If we have to send these folks away to do these clerkships somewhere else, there's a good chance we'll lose them to those communities. So this is actually important for us, and I think that our geographical isolation makes us somewhat unique to the whole discussion.
And for what it's worth, my understanding is Ms. Schwartz my understanding is that most of the community leaders in El Paso favored giving Burrell these clerkships. Is that correct?
That is correct. I actually ran into Dr. Lang, the president of Texas Tech, of Paul Foster, this morning at 5 a.m. at the El Paso airport, and we talked about it, and he assured me that he is good with this MOU and with the arrangement with Burrell.
And including community leaders like Paul Foster of the Paul Foster, Medical School
Yes, correct.
in
Woody
El
Hunt and
Paso. Yeah.
others.
So, anyway, any more questions? May I have a motion to approve consideration of adopting the Certificate of Advisory Council and Commissioner's recommendation to the board relating to a request from Burrell College of Osteopathic Medicine for an initial certificate of authority?
I'll move.
Motion by Ms. Swartz. Have a second? Second by Mr. Torn. All in favor? Say aye.
Aye.
Any opposition?
Nay.
Note, Mr. Raven voted no, but the motion passes. That concludes our special called board meeting. Do I have a motion to adjourn? Motion by Mr. Raven,
Second?
second by Dr. Farias. All in favor?
Aye.
Say aye. I presume there's no opposition, so the motion passes. Thank you.
Thank you.